3 things you should know when interacting with the police during a traffic stop. My name is Ellie Kazan. I was an attorney, now I'm a scholar. I create books. All this is going in miscellaneous advice. And so I'm going to just charge through this. If you want to save this video, you can. But yeah, I'm going to go kind of fast. The first thing is, operating a motor vehicle is a regulated activity. So you're giving implied consent to having your proof of insurance, registration, and driver's license. If you can't produce your driver's license or you don't have one, that's going to be an issue. So if you can be arrested and or the car can be impounded. If you have your driver's license but you don't have, like, your insurance is expired, you're most likely just going to get a ticket. But having a suspended license is a big deal. You can be, like, literally arrested on the spot for that. So people think like they can get out of these things, but there's no mens rea. There's no, oh, I forgot, or I was planning on doing it tomorrow, or I didn't know that my license is suspended. It's just kind of on the spot. It's an automatic statutory violation. So the second thing is, police officers can demand that the driver and or passenger step out of the vehicle out of officer safety. Again, this is not a question or a request. It's a lawful demand based off of officer safety, which the courts will side with usually. So it's as simple as that. If you stay in the car and you complain and you start yelling that you didn't do anything wrong and stuff like that, it can escalate. Officers can use reasonable force to get you out of the vehicle. And if it's really bad, that can escalate to you being tased, etc. So you don't have a lawful right to sit in the vehicle. Lower courts will also agree that officers have the lawful right to demand that you turn off the vehicle and put the keys on the dashboard. Again, all this is for officer safety. The third thing I want to talk about is searches. You've all heard of probable cause, so let's get right to it. Doing a pat down for weapons is just a frisk. It's not technically it's not a search. A search is more thorough of your possessions and of the vehicle. So let's do cannabis. In states where cannabis, CBD, THC is legal, the odor is not sufficient in and of itself to conduct a search. But if there's odor plus visible signs of impairment, slurred speech, you're voluntarily answering questions and you get shit wrong, then you're adding to their bucket. Similar with alcohol. I should say, in states where cannabis is illegal, the odor of cannabis is sufficient to search for probable cause. For alcohol, if they smell alcohol and there's visible signs of impairment, they can usually do a search there. Let's do plain view. If there's an open bottle, if there's drugs in plain view, if there's a weapon in plain view, that gives them probable cause to do a lawful search. The third thing is admissions. People will say, yeah, there's drugs in the glove box, or there's something something regulated and illegal in the trunk. So if you don't have a gun license and you can't produce that, and you're admitting that there's a weapon in the vehicle, that's obviously an issue. It's going to be probable cause to search. The fourth would be like consent. If they ask you, do you mind if I look in your vehicle, or may I look in your vehicle, you might think it's just a protective sweep, and it could be, but when officers ask that, they're usually intending to do a full thorough search. So if you're consenting, it's all recorded. It's going to go to court and be admissible. So let's just kind of put those scenarios to the side. If you're just on the street, someone calls the police on you, so they say you're sketchy, or there's a welfare check and police come up to you and they ask for ID, you can respectfully decline. They would have to have RAS, reasonable articulable suspicion, that you've committed a crime, are committing a crime, or in furtherance of committing a crime, in order to basically demand that you produce identification. So if they don't have RAS, they can't demand that you produce identification. Trespass is a very common thing, but you need notice that you were trespassing. So there has to be a sign, there has to be a fence, you have to have been told to leave. Those are all notice there has to be notice and there has to be intent to trespass. So you intended to stay, or you intended to be there. So if those two components aren't there, it's technically not a trespass, and they can't retroactively apply that and use that to demand that you produce identification, even in states that have stop and identify laws. So if you like this, it's going to be in my book, Miscellaneous Advice, coming out April 1st. Check it out. Thank you so much, and I hope that wasn't too much.